Thanks for joining us today. Just our quick disclaimer, this presentation is for educational purposes only. It's not legal advice and does not create an attorney-client relationship. We'll have some information at the end on contacting us if you have specific questions, sort of a follow-up to what Dan had just mentioned. We're also keeping an eye on the clock today so that we can provide this information, but keep your day moving and get you out of here on time. So we're just going to dive right into it, and we're going to talk about maybe one of the tougher parts of managing the employee life cycle within an organization, and that's termination. I mean, it's everybody knows that it can be great when you hire somebody, you're excited, maybe things are going well, you're looking forward to having um, productivity out of this person and a great working relation, but then maybe something happens quickly or maybe something happens down the road and then you need to look at exiting them from the organization. Or maybe somebody seems fine when they're hired but they become problematic quickly and you've got to remove them from your organization as quickly as you can to avoid future issues with this person or them creating issues for your other workers. Or maybe even there's a slowdown in business, unfortunately, that can create need to reduce some staffing levels. So there can be an interpersonal side to some of this stuff, for sure. And that's one thing that we want to look at today. But really, what we want to help you navigate is the legal and compliance risks, how to recognize those and how to reduce those legal and compliance risks. That's going to be part of what we're going to talk about as well. So we want to provide that information to help you go into the situation with your eyes open and being able to handle it properly. So let's say you've reached the point where you're deciding to let someone go. Again, it could be for something that happened now, it could be something that's built up over time, or it could be because of maybe a slowdown in business. As a starting point, prior to the actual termination, you'll want to think about some of these factors to help you evaluate what's happening overall. So we want to talk about each of these topics in turn and go through them. So the first one to look at is the employee employed at will. At will employment will definitely factor into your decision and how it's handled. Is there a risk of wrongful termination claims with the individual? Wrongful termination is definitely one of the factors you want to consider as the employer. Is termination actually needed? Would something else work with this person, another lower level of discipline or something else? And we want to talk about as we go forward, are there alternatives to termination? Is there something the organization could do short of getting rid of the person that could be taken as a step to keep things moving? So as we break out these factors, let's start with at will employment. So at will employment, okay, it's the rule in most states, and by most I mean 49 of the 50 states have at will employment. The state that does not have at will employment is Montana. If you have employees in Montana and you're one of our clients, we can certainly discuss that in more detail. But just generally speaking, most employees are employed at will. So somebody, what does that mean specifically at will employment? That means an employee does not have an employment contract. They have not been promised employment for a specific period of time, and then they are not covered under a union collective bargaining agreement. Breaking out those specific factors, employment contracts are not that common. They're seen for maybe some executive positions and for some specific types of jobs, maybe a teacher, maybe somebody in the media, maybe like a salesperson, a professional athlete, they might have an employment contract. Promises of employment for a specific time frame, you've got to be careful there because those could be made verbally if you're not careful, or they could also occur inadvertently if you have some imprecise language in your offer letter, for example. So you want to be careful there to not do that. You want to have the flexibility of at will employment. And union collective bargaining agreements might contain language regarding how and when an employee can be terminated. If you have an employee who's truly employed at will, again, no employment contract, no promise of employment for a specific period of time, no union CBA coverage. If somebody is truly at will, they can be let go at any time for any legal reason. And any legal reason means the termination just can't be based on something illegal, such as discrimination or retaliation. The person can be let go with or without cause. I'm using air quotes around that word cause. If somebody has an employment contract, frequently they talk about they can only be let go for cause. Well, that's a very clunky and sometimes difficult restriction to put on yourself. If you've got at will employment, you don't need cause. You can just let somebody go again, as long as it's not based on an illegal reason. And you do not have to provide them notice. Somebody who's employed at will can be fired on the spot. If something is going really wrong with a person, they can be let go. Again, provided that the reason you're letting them go is not based on something illegal, such as discrimination or retaliation. But conversely, with at will employment, the employee can quit on the spot too. So you've got to keep that in mind, that it's a two-way street. We sort of touched on this as we continue with at will employment, but it's not a free-for-all. You cannot just fire anybody for a reason. Again, if it touches into something that would be considered illegal, such as discrimination or retaliation. So here, there are a lot of laws to consider when you're letting somebody go, to not get into those areas of discrimination or retaliation. So for example, Title VII, that's a federal law that prohibits discrimination in employment. So you can't fire somebody just based on a protected characteristic. Maybe they're age 40 or older, maybe they're disabled, maybe they have a different religion. You can't fire them for those reasons. The Americans with Disabilities Act, the ADA, that's another federal law that prohibits discrimination based on disability. Under the ADA, an employer needs to provide reasonable accommodation to a disabled employee, subject to a couple of exceptions. So you can't basically get rid of somebody just because they're disabled. The ADEA, the Age Discrimination in Employment Act, yet again, another federal law. You can't fire somebody because they're aged 40 or older. The FMLA, Family Medical Leave Act, that's a federal law that provides up to 12 weeks of job protected leave for an employee's serious illness, a family member's serious illness, some military related things. You can't fire someone because they've used FMLA. There are also in the mix state human rights laws that are in many cases more permissive than these federal examples of rights laws that we just talked about. So you've got to keep those state laws in mind as well. You've got to look at these federal ones we've listed, but then depending on where your employee is located or employees that you're letting go, there are going to be state laws there as well that need to be factored into your decision. Some of the other laws you could come across are federal military leave laws, USERRA. There's workers' compensation laws in each state. There could be a state paid leave law. Many states have those now. There could be domestic violence leave laws. There could be state and local sick leave laws. Those are other factors to consider where you can't get rid of somebody because they've used, for example, job protected leave. Even with an at-will employee, that would be an impermissible reason to terminate someone. So at-will employment gives you the most flexibility. However, there are some limitations that you need to consider with each situation. And when you're looking at letting somebody go, you want to review that decision. You want to take a big picture look at it because you want to try to reduce your wrongful termination risk. Again, you don't want to get hung up on violation of anti-discrimination laws. Those, again, letting somebody go for age, religion, disability, their sex, their national origin, that they're in the military. You've got to look at all that protected class stuff. You've got to really be careful to make sure that the termination that you're taking can't be viewed as retaliation. For example, if somebody has engaged in protected activities and then they're fired shortly thereafter, they could say, well, they retaliated against me. Well, what are some of the potential areas of protected activity that could bring a retaliation claim against your organization. Well, somebody could have recently used job protected leave that might have been on FMLA. They might have been provided leave as a reasonable accommodation under the ADA. They could have used a state or local sick leave law. If somebody had a recent work comp claim, that is something to look at to avoid a retaliation claim. If they're a whistleblower, if they've participated in union organizing activities, if somebody has done some of that protected activity and then they are let go shortly thereafter, a risk of a retaliation claim could be there. You also have to be careful letting someone go who has complained to the company about something, say maybe some form of harassment based on protected class or sexual harassment. Either of those issues preceding a termination could also create risk for a retaliation claim. Um, the timing can be very important if it's close in time to somebody engaging in the protected activity and then shortly thereafter they're let go. Again, this is even as an at-will employee that can create risk of a retaliation claim against your organization. So as the employer, you need very solid reasoning in place when you're letting somebody go. And let's talk about some of those potential reasons that you might be able to rely on to help protect you. So one would be performance issues. Any performance issues with the person being let go should have already been accurately documented and documented at the time of the performance issue. It should not be something that you backdate and create retroactively a year later because you're like, oh, I want to get rid of this person, but I better paper the file first. Nope. The best way for your company to proceed is to be consistent with corrective action contemporaneously as it's happening. So if you're doing counseling, write-ups, a performance improvement plan, that should be documented at the time or very near in time. Don't try to backfill down the road. That doesn't help you. It's also a good idea to not lock yourself into a rigid discipline policy where, okay, if somebody does this, the step one discipline is verbal counseling. If they do this again, it's step two, a write-up. You don't want to have that rigid type of policy because then you're putting yourself in a box. You've got to follow that rigid policy every time for every violation. What if somebody does something really terrible? If you've got to follow a rigid policy plan, you're going to be shooting yourself in the foot because you're not going to be able to get rid of them as easily. You want to have a more flexible discipline plan that allows you to combine or skip steps within your policy as needed. The more flexible, the better, because again, that allows you to take action immediately if somebody is really doing something bad. The other thing to look at are policy violations. You want to make sure on the front side that your conduct standard has already been properly communicated to the employee. That's generally done by giving them an book. They sign an acknowledgement that has some of your legal requirements for your business in there and for the employees in the business. They've acknowledged that. That helps you if there's a policy violation. You want to be sure to also investigate any misconduct that is reported or that you observe. Document all of that. Be consistent with how you handle policy violations in terms of your discipline policy, looking into policy violations, or if there's any kind of incident that needs to be investigated, have that contemporaneous documentation for that as well. Another area that employees are frequently let go for are due to a reduction in force. That's changed business conditions. Unfortunately, right now, we're not having as much revenue come in, something like that. You want documentation of that as well. The point of discussing this is that you want to be able to point to legitimate business reasons for letting somebody go. You don't want to get into the area of something that could be questioned because it looks like it's retaliation or it looks like it's discrimination. You want to have those legitimate pieces of information in place showing the business reasoning behind letting somebody go. Don't wait to address issues. If you see something happening with employee performance or policy violations, do that right away. Make sure you're documenting everything and be careful of your reasoning again. This can sometimes come down to if you're an organization that has supervisors in there, you want to make sure that your supervisors understand this information as well so that they are not stepping on a landmine relating to, hey, this guy just made a work comp claim and we're firing him a week later. This looks a little suspicious. You want to make sure that you've got your management staff trained as well on this. Another thing to look at as you're reviewing a potential termination for your employees, are there any alternatives? We're not going to dwell on this too much, but we mention it here to make sure you're thinking about as many pieces of the puzzle as you need to when you're thinking about letting somebody go. So one of the areas that could be an alternative determination would be a performance improvement plan, or PIP. And that's a formal written plan for better performance with timeframes and benchmarks. For less serious issues, sometimes an employee may be placed on a PIP instead of terminated. I will say this, however, as a warning sign: if you do use a PIP, you got to follow it. You got to follow it. You as the employer can't slack on the terms of the PIP. You got to follow it completely. Reassignment sometimes is another area where something can be done with an employee who's having an issue, or if you need to cut staff, you could look at reassignment of somebody. If that's possible, it might not work for smaller employers. Obviously, we understand that. But if you have a bigger organization, it's a possibility the employee might fit better with another team or in another area of the company. That could help alleviate the problem and avoid the termination. Another issue is sometimes restructuring of the business or a specific department within the business. If the termination is going to be based on an economic downturn, an employee set for termination might be put into another department. That's kind of similar to the reassignment that we just talked about. But if you're doing an actual business restructuring or restructuring within your business of a certain area, you want to have good documentation supporting those economic conditions and the need to change things up through a restructuring. So let's say that you've gone through what we've just talked about. You've looked at the at-will employment status. You've looked at your documentation. You've looked at your reasoning. You're trying to, reduce your risk. What do you do once the termination decision is actually confirmed by your organization? You want to have good facts in place for the termination. You want to look at minimal disruption to the workplace, and you want to consider fair and respectful treatment of the person being let go. So those are just some of the benchmarks with a termination decision. You also want to prepare for the event. You want to consider severance, and you want to look at how the message is going to be delivered. So let's talk about each of these in turn. Preparing for the termination event. This is something that is very important within an organization. You want to have all your ducks in a row, as the saying goes. You don't want to come into this unprepared or not thinking about the factors. So what are some of the things to look at when you're preparing for a termination? You want to collect and review documents relating to the employee's employment. So that could be the offer letter, the restrictive covenant agreements, if any. That could be an agreement, separate agreement regarding confidential information or trade secrets. You want to look if the person has an employment agreement, if they have any sort of compensation agreement. Now, many of your employees may not have those extra documents, but you want to look at what they actually have signed with the company, starting with the offer letter, and then any other standalone documents they may have signed. You want to then go through those documents and see what is your obligation as the employer as it relates to termination, if anything. You want to see if there's something in there and make sure that you understand all of that written information on the front side. You've got to consider, as the employer, what are the employee benefit obligations with the termination. So maybe something like COBRA notices will need to go out if you offer group health insurance. Many employers use a third-party administrator. So if you're letting somebody go, you'd want to let your TPA know that. You have to consider, maybe you've got somebody that you've sponsored, they've come in from a different country. You may have an obligation to pay their transportation expenses if you're the sponsoring employer and the job is over. That's just something to consider if you're working with international employees that are in the country here. Make sure you know your final pay requirements. This differs greatly by state. Do you need to pay out a bonus or a commission under some sort of arrangement with the employee? Do you need to pay out your vacation and PTO under your regular policy and practice, or is it required under your state law? Your payroll provider, if you use one, may be able to help with some of this, but these are some of the points to consider. Prepare to provide the required notices. COBRA, as we just discussed, may need to be provided to the employees, or COBRA documentation may need to be provided. Maybe your state has a mini COBRA law. That's something to consider as well. If you're letting a number of people go, there's something called the WARN Act. It's a federal law regarding to large reductions in force and mass layoffs. Do you need to prepare a WARN notice under federal law? And maybe your state has a WARN law. If you're letting lots of people go at once, you want to be aware of those factors just in case. You want to look at the termination date. So for example, again, if your termination is a mass layoff that's covered under those WARN laws, you want to make sure that you're meeting the notice requirements. They require a certain amount of advance notice. That's something to be aware of. Another thing to think about is what if you're letting a single employee go and the person maybe is a little squirrely, you're a little worried about them acting up. You don't want to have a security issue occur if the person is hanging around the work site for too long afterwards. Make sure you look at a transition plan. Consider how the job vacancy is going to affect your operations. Johnny's being let go today. What is that going to do to the team that Johnny is on, or to the department that Johnny's in? You want to look at that information so that you've got a transition plan for your operations itself. Do you have a replacement lined up? Do you need a replacement lined up? Those sorts of things go into your transition plan thinking. Involve the necessary staff within your organization or your vendors, as the case may be, that are going to be related to the termination. So think of payroll for final pay, whether that's an internal payroll department, a payroll service, or both. They're going to need to coordinate final pay. Any benefits personnel, again, internally or as a vendor, that could go to a third-party administrator for COBRA, mentioning that again. Your people or department that contains your information technology services, you have to let your IT people know to shut off access for this person so that they can't get in and do something. And again, you want to think about, do we need to have security involved if the person is potentially going to cause an issue? And are there immigration issues? We touched on this. If you've got somebody from out of the country, if you're letting them go, there may be transportation expenses that you're required to cover. There are also other potential notices that may need to happen under or to the organizations USCIS and USDOL. There are rules to consider with letting somebody go if you're employing somebody that you've been sponsoring from another country. One of the big questions that we frequently get regarding terminations is, do I need to pay this person severance? Generally, the answer is no. It's different in the US. There are not laws requiring somebody be paid severance. For example, in other countries that have similar backgrounds in the evolution of law, think of Canada, think of the UK, you might in those countries, or will in those countries, have to pay somebody severance when they're let go. The US, that is not the case, generally speaking. What is an exception to that? If somebody has an employment agreement that says, if you let me go within this time frame, you owe me this amount of severance. So again, an employment agreement not used with the at-will employee, but if somebody did have an employment agreement for a specific position. Also, you want to check your offer letter that you use within your organization to make sure that it's not inadvertently promising severance in some ways. However, offering severance can be a strategic consideration for an employer. It's one tool in your toolbox where you can weigh the cost of paying severance versus the risk of not paying, what could happen with the person if they don't receive severance. So one of the ways that severance can be useful is when it's paid under a separation and release of claims agreement. It helps reduce risk to your organization. The departing employee, in exchange for signing the agreement, receives a severance payment. So with that arrangement, the employee is agreeing to give up the right to pursue certain employment claims against your company. So a lot of employers think about it as a way to pay someone to go away. Yes, it stinks that you might have to pay somebody that did a bad job when they're leaving, pay them more money. But if they sign a separation and release of claims agreement, you're essentially buying an insurance policy for your organization that they then cannot come back at you down the road for those claims. Um, Again, it's worth weighing the cost of a severance payment against the risk that the risky employee is going to come back at you. It might be cheaper to pay the severance than have to take your time, your effort, and then eventual money paid out to fight with that individual down the road. Defending a claim down the road where a severance agreement was not used could end up being more costly to your organization in time, again, and effort and money than it would have been to upfront pay them a chunk of severance, get them to sign the agreement, get them to go away. That's the reason why many employers do use severance agreements, because it's just a way to be done with it on the front side. More on the mechanics of the termination process. So another thing you have to think about when you're letting someone go is how are you going to deliver the termination message to them. This is another area where you want to consider your logistics on the front side in communicating information about the termination. So the timing and the location of the message. How is the message going to be delivered? Is it going to be done in person? Is it going to be done through an email, over the phone, by a video conference? Where will the message be delivered? Is it in a company office? Is it in a conference room? You want to make sure that you've got those factors lined up. You want to also have specific people determined in advance as to who will be involved. Is it only going to be one person if it's a video conference or phone call, just one person on that call? Actually, the best practice is to have more than one person to be involved in a termination meeting on the company side of things. That's true whether it's in person or through an electronic device like a phone or a conference, a video conference. You want to have at least two people from the organization there as a best practice. That would mean one person to speak to the employee. This is a single person being let go. And then the other person representing the company to observe, to take notes on what's being said, and then to serve as a witness to the conversation. We're going to touch on this again, but if you're doing an in-person termination, is security needed? Consider if the person might have a troubled reaction depending on your industry, depending on the individual. That's another factor to consider. What is the content of the message? What are you going to tell them about the termination? Generally, it's best to keep it very brief, to just stick to the facts, and don't say anything that's not true that person could turn around and try to use against you later. It's best to just keep it short, factual, and focus on the truth and the message you're delivering. It's smart always to anticipate employee questions with the termination. They're going to ask, why am I being terminated? They may have benefits question. They might want to just air their grievances in general. That's something just to prepare for on the front side in your mind as you're going into this situation. You want to have your paperwork lined up for the termination meeting. So if there's any required documents, have those ready. So in certain states, you're required to provide notices at termination. You'd want to have that paperwork ready. Many employers use a termination letter because that's a way to set the record of the date of what's happening with benefits, of the final pay, those sorts of things. If you're going to be offering severance, you might want to have that separation and release of claims agreement available at that time. Some employers, when they're letting somebody go, maybe, and this is rare, but it does happen, so we do want to touch on it. Maybe they then are saying, we're letting you go as of this future date, but we want you to stay until that future date. So here is a retention agreement. So sometimes a meeting can occur where they said, we're going to let you go, but we will pay you this amount of money if you stay for this remaining period of time under this retention agreement to help us through a certain project or whatever. If you've got someone you're letting go that has signed a separate document, such as a confidentiality agreement, you want to give them maybe a post-employment continuing obligations letter, So if they have a non-solicitation they've signed or a confidential information, you could also have a letter outside of the termination letter that addresses those continuing obligations. If your organization has an employee assistance program or EAP, sometimes that brochure is given. And you also, if the employee owes you money, you may want to have a wage deduction authorization form ready at the time. The rules vary from state to state on deductions from employee wages, including final pay. If you had a question on that, you'd want to ask us in advance to get more information on it, but that is a potential document that could be used in a termination, a wage deduction authorization form. So what if the employee brings up a disability issue during the termination? You know, somebody's work really recently fell off, or there was a pretty big incident. You've investigated, you've documented everything that's wrong. A couple of days later, you have the meeting, we're going to let you go. During the meeting, the person says, well, yeah, that incident occurred, but it's because I have this medical issue. So if you're having a termination meeting and somebody brings up a disability issue relating to the reason they're being let go, that is a tough situation. You may have to pause your termination at that point to go through the ADA interactive process to get more information on what's going on with the employee and see if a reasonable accommodation is required in that situation. But again, if that came up, that would be something where you'd want to reach out to someone like us to help you through that process. So you've had the termination meeting. Now you've got to move on to exiting the person. So with an immediate termination, disable their access as we touched on. So stop their access for their electronic devices and services. So their phone, their voicemail, desktop computer, laptop, tablet, social media accounts, whatever. Make sure that that access is going to be stopped at the termination. Generally don't allow further physical access to the work site. So that would mean if they've got a key card, that would have to be disabled. You also want to look at updating your payroll system and our HRIS permissions so that somebody maybe doesn't have full access. Maybe they could get in on a limited basis down the road to get a W-2, for example, but they don't have full access to the system. So you want to look at disabling an employee's access. You also want to consider return of your company property that the person has in their possession. So that could be something like a phone, a computer, a tablet, a car. You've got to think about how you're going to get your equipment back as a result of this termination process. If they have any other property of the company, so think of certain files, if they have reference books, they have other documents, you need to get that stuff back too. That's your property. And you also want to obtain written verification from the employee that's being terminated that all company equipment and property has been returned. That's a best practice. This might be the third time we're bringing it up, but I'm going to bring it up again because it's important. And this is something that actually lands in the news when this situation goes wrong. This is something you'll read about or see in a news program. That's the security aspect of terminating somebody. Now, some people might think that's a joke or they might think it's funny. Somebody, quote unquote, goes postal when they're let go, something along those lines. But unfortunately, it is a real issue. And again, if you're concerned about an employee's reaction to termination, consider having security personnel on standby. Security can sometimes be posted right outside of a meeting if that's needed. Maybe they're on call at another location near the work site. You've got to think about your parking lot. Once this person is out of your building, if their car is still on your property in your parking lot, you've got to think about getting them out of there potentially as well. If you're using security personnel or if your work site or work location already has security personnel, those individuals can be told that the employee should not be allowed to return to the work site or other company property. If you've got security personnel already, you leverage those folks to help you with termination situations. If you're letting somebody go and they don't know what's coming, you've got to consider what to do about their personal belongings. Do you want to allow them to go back to their work area and pick up their stuff? Are you going to give them a box and then help them move their stuff? Some employers do that depending on the specific situation with the individual. Others do not, because that could be too disruptive. The person could be saying a bunch of negative things as they're walking through the work area, be disruptive in another way. So many employers, instead of doing that, they just box the personal items after the person's been escorted off the property. They box their personal items and then they ship them to the employees uh, where they live. Um, if you are doing that, if you are going to handle the person's possessions and send them back because you're not going to allow them to return to their work area, as an employer, it's a good idea to take photos and document any possessions that you are boxing up and sending to them so that then there's no dispute later. They said, where's my family portrait with the $40 frame on it? You've got a picture of it. You putting it in the box, that's going to help defeat any claim that they might have that, oh, you never gave me that item that's valuable to me. After the employee has been terminated, generally employers are notifying other workers of that person's separation. So if you're letting your current staff know, you don't have to get into a bunch of details. And in fact, you should not get into a bunch of details. Keep it very simple. Could be something like Frank Smith is no longer employed at XYZ Corporation. The message can literally be that simple. Only the people who have a need to know, such as human resources, should be aware of the details of the termination. You don't want all that extra information circulating amongst other workers that don't work in the management part of the business or don't work in the HR part of the business. That just is a setup for liability for your organization. You want it kept closely on a need to know basis only. It's okay to explain a transition of work while someone's position is vacant. You can say Frank no longer works here. Jenny will be covering his work for the foreseeable future. Could be something like that. Do not make any statements about the individual that could be perceived as defamatory. So don't say Frank was let go because he was doing a bad job. Just say he no longer works here. You don't want to get into something that could be actionable and come back at your organization. If you're talking to relevant business partners, customers, things like that, you can let any business contacts of the terminated employee know. You can introduce the other staff who will take over ongoing projects or relationships. That's okay to do, but again, you don't want to get into a bunch of details about what was going on with the individual. It's simply best to say they no longer work here. If this person had access to company accounts, they worked with your financial institutions, they worked with your vendors, you want to contact those folks as well and let them know Frank's no longer going to be handling this. It's going to be Jenny now. Generally speaking, employers also have an obligation to notify their state unemployment insurance office as well. If you receive a notice of an employee filing an unemployment claim, you have an opportunity to respond to whatever the employee is claiming inside of their statement of why they should get unemployment. When you're responding to the state, you've got to be truthful and you've got to be consistent with any statements. Don't say one thing to the employee and say something else to the state unemployment office. If you hand the employee a termination letter and say they were terminated for reason A, but then you tell the state unemployment office they were terminated for reason B, that conflicting information is not going to look good for you, and it could result in the state saying, well, the employer can't get his story straight, so this person's going to get unemployment. In this day and age, it's also a good idea to be prepared for negative social media reaction. Many employees don't take their termination well, so they sound off on social media. If that occurs and you have a concern, you need to look at each situation on a case-by-case basis. Some companies, they work with consultants on how to respond to former employee complaints online. Others ignore what their person is saying and let them vent. As long as the person isn't saying something defamatory against the company. And just so you know, defamation is a legal term. It's not disparaging. Disparaging the company is saying something like their products are no good. Defamatory is a specific defamatory statement can be specifically legally actionable. because it's beyond saying something that's bad. You're saying something that's false against the company. It's posting it to other people, and it could actually harm your business. An example would be disparaging the company would be something like saying ABC's products are no good. That's not actionable. But if the person said ABC company is manufacturing and selling controlled substances out of their warehouse to kids, that's defamation. So you want to look at what the message is when you're determining how to respond. So somebody's been let go. You're in the post-termination phase. What are some factors to consider with that? Again, this reinforces some of the other points we talked about previously, but they're important enough that we want to reinforce it. Make sure your benefit notices are sent, COBRA, whether that's from you internally or your third-party administrator. Make sure you've got a policy for personnel file access. Many states have laws that require employers to provide specific information that would be considered a personnel file if a former employee asks for that information. You've got to look at the laws in your state if somebody's making a request for their personnel file. Regarding an employment reference, it's best to be extremely careful. A lot of employers only stick to confirming the dates of employment and positions held. So those are very factual pieces. You were employed from May of 2023 to June of 2025. What position were you in? Quality manager. That kind of information is generally safer to provide because it's not disputable. It's not always without risk. If a new prospective employer says, would you reemploy this person? That could potentially open the door. If you respond to that question, that could open the door if you say no to that former employee trying to make some sort of claim against your organization. That risk might not be giant, but it would be there. So many employers have policies of saying if they're asked that question or ask for a reference, they say, we don't comment on reemployment. All we tell you is the dates of employment and the positions held. Make sure that you're keeping full documentation relating to the employment of the employee who's been let go. Most states have very strict record keeping laws. So that's things like date of hire, rates of pay amounts each week, hours worked. It can be all kinds of stuff, and it's state by state by state. Make sure you've got that information saved as needed for the number of years needed. You need to keep it. You also want to maintain confidentiality. Termination information, again, should only be shared on a need-to-know basis. That's not everybody's business. Don't give details to those outside of the loop. It needs to be closely held within the specific team in your organization that handles that type of function. So how can we help you with this area of your business that unfortunately has to come up sometimes? How can we help you with termination questions? Well, we advise on termination situations all the time. I mean, almost daily, if not daily. So if you've got a question, make sure you ask us. That's probably one of the most common types of questions that we receive. We can help you evaluate your termination risks because we're going to look at the federal, state, and local laws and apply them to the facts of the situation you're in. And we can provide you with information policies relating to termination. What are the post-termination documentation requirements in your state? We can let you know that. We can assist you with discipline policies. We can help you with severance agreements. So we've got a good slew of information and resources that we can provide to our clients on this topic. I think Dan has some follow-up.
Yes, thanks, Michael. And thank you all for attending today. We appreciate you joining us and taking some time out of your day to learn more about this important topic for HR and business owners. If you have any questions about conducting employee terminations or on any of the material covered, we do ask that you open a ticket in our Ask an Attorney portal. We can provide you with a specific legally backed answer. If you're not a client and would like more information, Their information here is listed. Please reach out, schedule a demo. We'd love to show you our Ask an Attorney portal, provide information on our services and how we can help your business. If you have any further questions, please email us at info@myhrcouncil.com, and we hope to see you on another webinar of ours in the future. We hope that you have a great rest of your day.
Thanks, everyone.